Hello everyone. In this second series of presentations on criminal law, some important specific offences under the Indian Penal Code will be explained. The first in the series would be on culpable homicide and murder. All murders are culpable homicides, but all culpable homicides are not murders. Why? What are the elements which, when present, would make a culpable homicide amount to murder? To know this, we must first of all know what is homicide. Now, what is homicide? Killing of a human being by another human being is homicide. Culpable homicide is unlawful homicide. Now, can homicide be lawful also? Yes. When the homicide falls under any of the excusable or justifiable circumstances specified under sections 76 to 106, that is, under the general exceptions enumerated in Chapter 4 of the Indian Penal Code, then such homicide is not unlawful or culpable. Thus, death caused by a child below 7 years of age, by an insane person, or in exercise of the right of private defense do not amount to culpable homicide. Unlawful homicide can be classified into three categories: culpable homicide, murder, and homicide by negligence. This classification is based on the degree of intention, knowledge, or recklessness with which a particular homicide is committed. Now, what is culpable homicide? According to section 299 of the Indian Penal Code, when death is caused by doing an act with an intention of causing death or with an intention of causing bodily injury which is likely to cause death, or with the knowledge that the act is likely to cause death, it is culpable homicide. Here, death means the death of a human being. Act includes a single act as well as a series of acts, a single omission as well as a series of omissions, or certain acts as well as omissions. Thus, death must be caused with one of the mental elements specified under section 299 to constitute the offence of culpable homicide, that is, with the intention of causing death or bodily injury which is likely to cause death, or with the knowledge that the act is likely to cause death. It must also be shown that the injury caused by the act of the accused had resulted in the death of the victim. That is, the cause and effect relationship between the act of the accused and the death of the victim has to be established. Now, when will culpable homicide amount to murder? Murder is defined under section 300 of the Indian Penal Code. It says that when death is caused by doing an act with an intention of causing death, with an intention of causing bodily injury which the accused knows is likely to cause the death of the victim, or with the intention of causing bodily injury and the injury so inflicted is sufficient in the ordinary course of nature to cause death, or with the knowledge that the act is so imminently dangerous that death or bodily injury likely to cause death would be the most probable result of the act, and the act is done without any justification or excuse, it is murder. There are certain exceptions provided under section 300, and if the case can be brought under any of these exceptions, then even if death is caused with any of the above mental elements, it would still amount to culpable homicide, not amounting to murder. Now, let us try to understand the scope of these two sections with the help of two cases: Virsa Singh versus State of Punjab and State of Andhra Pradesh versus Rayavarappu Punnaya. In Virsa Singh's case, the accused stabbed the victim with a spear. He thrust the spear in the abdominal region of the victim, resulting in serious injury which caused the death of the victim. When prosecuted for murder, the accused pleaded that he just stabbed once with the spear and hence his case should fall under section 299 and therefore he should be liable only for culpable homicide not amounting to murder. But the trial court held him liable for murder under section 303 and sentenced him to imprisonment for life. The High Court upheld the order of the trial court. Virsa Singh appealed to the Supreme Court. For clarity, the provisions of section 299 taken as clauses A, B and C based on the three kinds of mens rea specified under the section are compared with those of the 4 clauses of section 300. Under clause A of section 299 and clause 1 of section 300, death has to be caused by an act done with an intention of causing death. Therefore, whenever there is an intention of causing death and the act is done with such intention and death occurs, it is murder. Clause 2 of section 300 is peculiar to section 300, there being no equivalent to this clause in section 299. Under this clause, the victim must be in a peculiar or abnormal situation, that is, he must be suffering from some ailment or must be too young, etc. The accused must be aware of this condition and he must have intentionally inflicted a wound which is likely to cause the death of the victim, and it actually resulted in the death of the victim. Here, the injury may not be sufficient to cause the death of a normal man, but it caused the death of the victim because of his peculiar condition, and the accused knew about this and intentionally inflicted the injury which resulted in victim's death. Here, the accused would be liable for murder under section 302. For example, where A is suffering from diseased spleen and B, knowing this, gives a punch in the abdominal region of A, causing rupture of spleen, which results in the death of A. Here, B will be liable for murder. Regarding clause 4 of section 300 and clause C of section 299, the mental element required is in the form of knowledge. Under section 299C, the act causing death must have been done with the knowledge that the act is likely to cause death. But when the act is done knowing that it is imminently dangerous and the most probable result of the act is death, and it is done without any excuse, it falls under section 304. Firing indiscriminately on a crowd resulting in the death of a person would be murder under section 304. Whereas hitting a person with a lathi on the head causing concussion that resulted in his death would be culpable homicide not amounting to murder under section 299C. Now coming to clause B of section 299 and clause 3 of section 300, when injury is inflicted intentionally and it is such as is likely to cause death, it is culpable homicide not amounting to murder, but where the injury intentionally inflicted is sufficient in the ordinary course of nature to cause death, it is murder. Here again, the gravity of the injury and the degree of probability of death being caused would determine whether the accused is liable for murder or culpable homicide not amounting to murder. In Mirza Singh's case, one severe blow was inflicted in the abdominal region of the victim with a spear. It was thrust into the abdomen and the victim died because of the injury inflicted by the accused. In order to bring the case under section 301, intention to cause death has to be shown. As the injury inflicted was only one blow with a spear in the abdomen during an altercation or fight, it cannot be said that there was an intention to cause death. The case also cannot be brought under section 302. As there was intentional inflicting of injury, the case will not fall under section 304. Now the question that remains is whether the case falls under section 299B or under section 300 clause 3. In order to bring the case under section 300 clause 3, the prosecution has to first establish that the bodily injury was inflicted by the accused. It must then be proved that there was an intention to inflict that particular bodily injury and it was not accidental or unintentional. For example, where the accused was just threatening when another person pushed him with force because of which the spear got thrust into the abdomen of the victim and the like. Then the nature of the injury has to be proved. This is purely an objective inquiry, that is, the weapon used, the part of the body injured, the force with which the injury was inflicted, etc. have to be examined. It is finally to be proved that the injury was sufficient to cause death in the ordinary course of nature. This part again is purely objective and inferential and has nothing to do with the intention of the accused. The question is whether the accused intended to inflict the injury in question, and once the existence of the injury is proved, the intention to cause it will be presumed unless the evidence or the circumstances warrant an opposite conclusion. The Supreme Court held that the accused was rightly convicted under Section 303 and sentenced to imprisonment for life under Section 302 for the murder of the victim. Now coming to the second case, in state of Andhra Pradesh versus Rayavarapu, the victim, a man aged about 55 years, was beaten by the accused, who were 5 in number, by thick lathis, restricting the blows to hands and legs without injuring any vital part of the body. The victim suffered more than 19 injuries, out of which 9 were serious, because of which he died. The doctor's report stated that though each injury taken by itself is not sufficient to cause death in the ordinary course of nature, the cumulative effect of the injuries inflicted was sufficient to cause victim's death. The accused contended that they cannot be liable for murder but only for causing hurt or grievous hurt, because each injury inflicted as such was not sufficient to cause death. The trial court held the accused liable for murder under Section 302. The High Court of Andhra Pradesh allowed the appeal made by the accused and held them liable only for culpable homicide not amounting to murder under Section 299C. The state went in appeal to the Supreme Court. The Supreme Court held that Section 300 states that when death is caused by doing an act with the intention or knowledge specified therein, it would amount to murder. Here, act includes a single act as well as a series of acts. The weapons used in this case were thick lathis. The blows were aimed on hands and legs, which were pounded so badly that it resulted in fracture and dislocation of bones and caused hemorrhage. All these injuries were intentionally inflicted and death was caused because of these injuries. Though each injury taken as such may not be sufficient to cause death, the post-mortem report states that these injuries taken collectively and cumulatively were sufficient in the ordinary course of nature to cause death. Hence here, death was caused by a series of acts which were proven to be intentionally done, and they were sufficient to cause death. The Supreme Court therefore reversed the order of the High Court and held the accused liable for murder under Section 300 Clause 3 of the Indian Penal Code. Thus, when death is caused by an act or a series of acts or omissions, or by acts as well as omissions, with an intention to cause death, it is murder under Section 301. When it is caused with an intention of causing bodily injury and the injury so caused is sufficient in the ordinary course of nature to cause death, it is murder under Section 303. If the injury inflicted is only likely to cause death, it is culpable homicide not amounting to murder under Section 299B. If there is no intention but the person does the act with knowledge, if the act is imminently dangerous and done without excuse, it is murder under Section 300 Clause 4. If it is not so dangerous but is likely to cause death, it is culpable homicide not amounting to murder under Section 299C. Culpable homicide is the genus and murder is its species. Murder under Section 300, which is culpable homicide of first degree, is punishable under Section 302 with death or imprisonment for life. Culpable homicide not amounting to murder under Section 299B, which is culpable homicide of second degree, is punishable under Section 304 Part 1 with imprisonment for life or imprisonment up to 10 years and fine. Culpable homicide not amounting to murder under Section 299C, which is culpable homicide of the third degree, is punishable under Section 304 Part 2 with imprisonment up to 10 years and fine. Now, even where the case falls under one of the conditions specified under Section 300, a person will still be liable only for culpable homicide not amounting to murder if he can bring his case within one of the 5 exceptions provided under Section 300. These exceptions will be explained in the next presentation. Thank you.